Straight ahead on Law and Crime Daily. Public officials and the ex-cops involved with the police killing of Breonna Taylor seek to throw her boyfriend's lawsuit against them out of court.
A father and son charged in the Ahmaud Arbery case ask a judge to set bail. Do Gregory and Travis McMichael pose a flight risk?
Is a mental health diagnosis enough to take the death penalty off the table for a former pro baseball player convicted of triple homicide?
Also been, engaging in violent acts with teammates and his family members.
And the discovery of prosecutors' racist emails leads to a woman's exoneration. Law and Crime Daily covers court cases from coast to coast.
And welcome to Law and Crime Daily, everybody. I'm Aaron Keller, along with Brian Buckmire and Terri Austin. A hearing in a civil suit against a former Louisville police officer filed by the boyfriend of Breonna Taylor. Kenneth Walker is suing Detective Brett Hankinson and others claiming violations of Kentucky's Stand Your Ground law. Walker says he was illegally detained and charged after he used his legal firearm to fight back who he thought were intruders, but who turned out to be Hankinson and plainclothes officers. Walker alleges assault, battery, false arrest and imprisonment, malicious prosecution, abusive process, negligence, and other claims. A representative from the Attorney General's office said Walker failed to state a claim, didn't suffer legally recognized injuries, and had no standing to sue.
There are three principles to standing, and that is injury, causation, and redressability. And it is the plaintiff's burden to demonstrate each of those. And here, they plainly cannot, Mr. Walker cannot prove that he has any injury, in fact, that is traceable or caused by the Attorney General. The traceability or causation is for the reasons I outlined above, and that's the Attorney General's statutory authority in matters like this, which is not. It's more secondary to when he's requested to step in. That has not occurred here. The Attorney General has made clear he's not investigating Mr. Walker and has no authority to prosecute Mr. Walker, especially where Mr. Wine has retained that portion of the investigation and potential prosecution. It's a mere hypothetical that he is posing here. It is the case, perhaps, that he may not be indicted at all.
An attorney for the local prosecutor made similar arguments and said that office was doing the correct thing. Brian, listen to this.
Tom has promised to take the appropriate action in this case, just as he has in every case. His decision as to whether that means to seek indictment or to make efforts to amend the dismissal of the prior indictment to be one with prejudice must be made on his time, subject to his investigation and in his prosecutorial discretion. And for these reasons, we ask that all the claims against the Commonwealth's attorney in the plaintiff's first amended complaint be dismissed and the Commonwealth attorney no longer be a party to this action.
Okay, so Brian, that seemed pretty aspirational for an argument from a defendant in a civil case about wrongful arrest, basically. And I could almost hear the trumpets of righteousness sounding in the background. Do you think the prosecutor is really doing the right thing in this case?
Do I think they're doing the right thing if I open up a legal book and look at what the steps they could and could not have taken? Probably, but I think from a moral standpoint, there is some error there. But unfortunately, I think the prosecutor is right. When you're measuring the harm that occurred here after the fact, I'm not talking about having Breonna Taylor die in his arms. I'm talking about the prosecution after the fact. It's going to be very hard for Kenneth Walker to point out damages when they drop the case.
Let's move on now. Attorneys for Kenneth Walker said he was injured when he was arrested and charged the first time, and that the law allows them to sue to recover for the past harm and prevent any future harm.
The defendant's arguments overlook the fact that Mr. Walker already has been harmed. He already was improperly arrested and indicted. The fact that that Mr. Walker might again be arrested and indicted in the future, the fact that that is, as it was characterized, a near hypothetical because it might not happen, is exactly what the Declaratory Judgment Act is designed to address. And that, again, is pretty simple. It is injury that is either actual or imminent, that has been caused by the defendant, and that can be redressed by something the court can do. The U.S. Supreme Court has made clear that the plaintiff can file a declaratory judgment action before the harm occurs. The defendant's arguments ignore that Mr. Walker has already been harmed. He's already been arrested and indicted in the past. And just those actions alone are enough to support standing.
The judge questioned whether he had to let the AG's office off the hook in this case, but not the prosecutor who filed the charges. The defense countered that the AG could take over the case at any moment and charge Walker yet again in the future, and that Walker needed to sue the AG right now to prevent that. So, Terry, I say this case should not be thrown out. It seems clear to me under Kentucky stand your ground law that Walker was harmed when he was charged when he was practicing self-defense.
Aaron, I could not agree with you more. I reviewed Walker's complaint in great detail, and it alleges he had the right to stand his ground, and he did. He was in the right place, and he had a gun, and he was being attacked, and he wasn't committing a crime. And he also alleges in his complaint these tort claims, like you mentioned, the malicious prosecution and the abusive process. And he definitely has been injured. He suffered, they treat him like a criminal. So he definitely suffered some trauma and humiliation. I think he has a right for that.
Kentucky law protects against that. Now, keep in mind, Detective Hankinson is also facing other legal trouble, apart from the Kenneth Walker civil suit and apart from his ongoing criminal indictment related to the Breonna Taylor case. A woman is suing Hankinson for what she says is a 2018 sexual assault. The plaintiff, who was a law student, says it happened after Hankinson gave her a lift home from a bar where he was working security. She says she fell asleep intoxicated and that she awoke to Hankinson assaulting her. She says she tried to get him to stop and says Hankinson tried to later suggest the whole thing was consensual. Police have made an arrest in a hit-and-run crash that killed a prominent defense attorney in Cincinnati, Ohio. Angenette Levy has details about the person who's now behind bars.
The man charged in the crash that killed attorney Steve Adams turned himself into police in Cincinnati. A judge set his bail at $500,000 cash. This is his booking photo. He's 22 years old and his name is Brandon Marksberry. He lives a short distance from where that crash happened on November 1st. He faces a felony charge. Marksberry is accused of hitting Adams as he rode his bike early that morning and then taking off. A woman who lives nearby heard the crash and comforted Adams as the ambulance arrived.
I just sat out there with them until the ambulance came. The kid talked to the ambulance. I sat there and talked to, his name's Steven, but I talked to Steven and just kept telling him, hold on, the ambulance was coming. He wasn't talking, but he was moving his eyes and his head, but he was bleeding. He had his helmet on. He had full gear, biking gear and stuff like that. So, but he wasn't. He wasn't able to move until he heard the ambulance, and he tried to roll over and get up.
Right now, Marksberry faces that one felony charge, but there could be additional charges added when the case goes to the grand jury. For Law and Crime Daily, I'm Angenette Levy.
And still ahead on Law and Crime Daily, a new trial date for the so-called doomsday husband and wife charged in the Idaho disappearance of 2 children. And later on, could 2 men be let out of jail despite charges they shot and killed a black man while he was jogging? Law and Crime Daily returns with that case in just a moment. Welcome back, everybody. The so-called doomsday cult couple, Lori Vallow and Chad Daybell, have a new trial date. The husband and wife are facing 2 felony charges related to the disappearance of Vallow's children. The bodies of 17-year-old Tylee Ryan and 7-year-old J.J. Vallow turned up on Chad Daybell's property. The husband and wife were scheduled to be tried together in March, but the date has now been pushed back to next July. A bond hearing to determine whether 2 of the 3 defendants charged with murdering Ahmaud Arbery in Georgia can go free before trial. Now, this hearing involves Gregory and Travis McMichael, the father and son accused in the case. Prosecutors say Gregory McMichael started chasing Arbery as he left a construction site. Son Travis McMichael is accused of firing the shots. They both claim self-defense. The state says the defendants could pose a danger to society and cites racist text messages between the men and their friends.
Do you recall that text exchange between you and defendant Travis McMichael in which he was talking about shooting a black coon with gold teeth that had a high point .45?
He was referring to a raccoon.
Okay.
No.
A raccoon with gold teeth and a high point .45?
It was being facetious, not him.
To which you responded that this raccoon needed Newport cigarettes. Is that your testimony?
Yes, sir.
The defense says this case isn't about race, and the defendants don't pose a potential flight risk despite an ongoing Department of Justice investigation into potential hate crimes.
We believe this murder case here in Glenn County is defensible and winnable. I look at that hate crimes case, if the feds ever do bring one, as eminently defensible and winnable. In order to address the court's concern that we might pose a significant risk of flight if released on bond in this murder case, because we have some fear that the feds are going to come arrest us and charge us in federal court with a federal hate crime, where I am even more confident that that case could be beaten. Based on the statutes that I'm familiar with, based on the types of cases in these press releases that they do prosecute, they're really meant to illustrate this is what federal hate crimes cases are really about. And this case is not one of those.
Okay, Brian, so 4 different friends of the McMichaels, the defendants, offered to put up their homes for the purposes of bond. But one of the friends also said Travis McMichael developed the skills to go completely off the radar as a hunter. So talk about a mixed message from the friends.
Yeah, that's not what you want to tell a judge when the prime question is whether or not this person is a flight risk. If you have the skills to literally fall off the map and not be found, that's something that's going to give the judge some pause, regardless of how many homes are going to be put up as collateral.
Exactly. So now, Terry, something else we've got to get out of the way here. When we talk about bail reform, we're generally not talking about this type of offense alleged.
Well, that's right. Most of the time when you're talking about bail reform, like in New York or New Jersey, we're talking about eliminating cash bail for low-level misdemeanors and non-violent crimes. So here, you see obviously that the defendants have been charged with felony murder and, assault. And obviously, these are not the type of crimes that we're talking about. And, one of the reasons why we have bail reform is to make sure that we don't have this 2-tier system advantaging those with money and disadvantaging those without money. So this is not one of those cases.
Exactly. We're talking about much lower level offenses. And as Brian pointed out, usually the point of bail is to ensure someone returns to court, not punished. But as the friend testified here, that may still be an issue. And when we return here on Law and Crime Daily, death penalty arguments in the case of a pro baseball player accused of triple murder using his own bat. Plus, a Massachusetts woman is believed to be her state's first exoneree based largely on racist emails written against her by the prosecutor's office, which sent her to prison for 17 years. We'll look into that case after the break. Now to the story of a Massachusetts woman tried not once, not twice, but 3 times for murder in a deadly fire which killed her parents. The first 2 cases resulted in hung juries. A conviction finally stuck until appeals lawyers uncovered a series of racist emails from the prosecutor's office which tried the case against the defendant, Frances Choi. I spoke recently about the case with reporter Deborah Becker from WBUR Radio.
I had heard about the case a while ago and had heard about the email a while ago because they actually came to light in a different case. And this was in a dispute within the Plymouth County District Attorney's Office, the office that prosecuted Frances Choi. And there were mentions of racist emails on the part of prosecutors. But then a defense attorney for Frances Choi wanted to see these emails and to see if these racist emails were referring to his client, Frances. And it took him years to get them. So it really was the work of a very dogged criminal defense attorney that brought all of this to light.
It was a 5-year process, as I understand it, to even get those emails. Why did it take so long?
Well, there was a lot of stonewalling, quite frankly, on the part of the DA saying, we're not sure what exactly you want with these emails. We don't know which ones you're talking about. It went to the state's highest court, and the court ruled, no, you have to turn over all the emails.
What do the emails actually say?
The emails are really disturbing. They're very disparaging against Asian Americans, against the defendant in this case and her family. They make a lot of mocking references and make fun of the trial. We thought, really? I mean, were prosecutors really writing something like this? It was mind-boggling.
The prosecutor's office has apparently promised reforms. Did those reforms go far enough, and have they been implemented?
Well, it's hard to know if they've gone far enough. They say again, pointing to this case, they say that that they are showing that they take this very seriously, and they will not allow racism to affect their work. And they will not allow racism within the ranks of their prosecutor.
The people that actually wrote the emails are out of that office now. That's my understanding, correct?
They are, and one of them is a prosecutor in another county in Massachusetts.
Do you believe this defendant is factually innocent?
Certainly the government here didn't do a good job in proving this case, and there were just way too many factors to bring this forward again. I think that there are too many questions about the evidence, the testimony of a key witness, and then these racist emails on top of it. I don't see how they could have gone forward. People are outraged by it, and I think there's a lot of sadness that someone lost 17 years of her life, and those 17 years, during that time, she's proven to do some exemplary things in prison, getting an education and taking all kinds of programs to better herself.
Frances Choi, the exoneree, said in a statement that she hopes her life outside prison will honor her parents who died in that fire. Her conviction was based on a shaky bit of testimony from a nephew who changed his story to claim Frances Choi made him write notes about how to set the deadly fire. And when we come back here on Law and Crime Daily, life or death for a former pro baseball player? That's the question. His defense claims he's mentally ill and should not be executed. A former pro baseball player is now facing a possible death sentence after a jury convicted him for committing 3 murders. Brandon Willie Martin was found guilty of slugging to death with a baseball bat his own father, his own uncle, and a security system installation man. The jury must now decide whether Martin should be locked up in prison for the rest of his life or whether he should be executed. Terri Austin picks up the case from there.
Aaron, a psychologist testified for the defense that she began treating Martin in 2012 and diagnosed him with paranoid schizophrenia. She saw him again in 2014 after his baseball team fired him.
And what did Brandon tell you that day?
You and my mother are trying to dope me up, so I will not play baseball again. I don't need to be here.
So he's basically accusing you and his mom of trying to medicate him so he can't play baseball again. Is that correct?
Correct.
That phrase that you wrote there, is that fall in line with your diagnosis of paranoia and schizophrenia?
Yes, he was clearly paranoid even against me, that I'm trying to hurt him, not to help him.
And again, you put the severity level at high, correct?
Yes.
The risk level at high, correct?
Yes.
The psychologist prescribed Abilify for Martin and created a psychotherapy plan. On cross, she told prosecutors she saw no suicide or homicidal tendencies.
I have people talking in my mind.
Right. But those people, I mean, those people could be Jiminy Cricket sitting on his shoulder telling him to do good, for all you know. Right?
Yes, we can only assume, but could have been at the same time a demon telling him to kill people, and he didn't detail about that.
Right. But you would expect that would be an important piece of information if it was known.
If it was a no?
If it was known.
Oh, if it was known, yes, very,
right.
very important,
so
yes.
If Mr. Martin or Mrs. Martin said, you know what, Brandon was going around saying that these demons were telling him to like hurt animals, you would expect that would come out in this.
Yes,
right?
Yeah, but probably they didn't hear him saying this thing.
Right.
Psychologist and law and crime expert Dr. John Delatorre says the notes from Martin's psychologist indicate Martin needed more mental health care.
He seems to be deteriorating, but there's no clear reason as to what exactly is going on. So just because someone is complaining that that someone's prescribing them drugs doesn't necessarily make it a delusion. It's probably true that he's not able to compete at a high level because of the drugs that he's taking. But what makes it a delusion? Is he saying that they're purposefully dosing him with things and that's the problem? Because then he should be in a higher level of care, not continuing to see an outpatient psychiatrist.
So Terry, so many accusations of substandard care here. How does the jury take that all in and weigh whether or not this man should be sent to the death chamber?
Well, you know, he clearly has some mental illness. We heard testimony from the psychologist. We heard testimony from his brother about his behavior. So I think the jury is going to take that into consideration. And I think they will probably agree with Dr. Delatorre and say he needed more help and he should not spend the rest of his life in a jail and he should not be put to death. He needs to be in a mental institution with some mental care.
Brian, do you agree with that assessment?
Absolutely. And sometimes when you have trials like this, the jury wants to find the bad person. And as a defense attorney, far too many times that's your client. But here, it seems the defense has the ability to kind of shuffle that away to say, this is the bad person, and my client is actually a victim in one way, shape, or form.
So if the jury is able to find some sympathy and say he didn't get the care he deserved, then maybe that sympathy will mean it's a life sentence. But they did find him guilty, so that stage of the case, of course, is done. Thank you so much for joining us here on Law and Crime Daily. We very much appreciate it. We'll see you next time as we discuss these and other cases. There's a lot to talk about when it comes to justice in America.